got things to do. So good morning, everybody, and welcome to today's question and answer Ask an Expert webinar. My name's Melissa Wheeler, and I'm the Marketing and Events Manager at Fiducia Wealth Management. Fiducia Wealth Management is a multi-award winning chartered firm based in Dedham that specialises in delivering tailored and bespoke financial advice and wealth management guidance to individuals, trustees and businesses. Our partner today, Goody, Burrett LLP, is a Lexcel accredited law firm with offices in Colchester and Dunmow. The firm offers over 300 years of experience in providing the very best service to their clients, both commercial and private. Now, before we get started and I pass you over to today's presenters, Susie and Georgina, I'm going to walk you through the agenda. It's not very complicated, but first let's just start with some house rules. I have already done this my end, but please keep your microphone muted throughout the webinar. You may have some specific questions relating to your business, well, we're hoping you will, or related to the specific content later. Please send these through to me through the chat facility if you haven't already emailed me, and I'll read these out during the Q&A session at the end. Feel free to take any notes. However, we will be sending you an edited recording of the session in the follow-up. Other than that, I hope you're all in good spirits and ready to receive some answers to your questions relating to complex issues of property and inheritance planning. So on today's agenda, shortly we'll be hearing from Susie Laws, Chartered Financial Planner and Director at Fiducia, who will answer some of the most frequently asked questions relating to the financial aspects of property planning. We'll then pass on to Georgina Layton, a private client solicitor at Goody Burrett, who will tackle questions of a more legal nature. Once again, we'll have a quick Q&A session at the end to wrap things up, anything that will have come to your mind throughout the session. But again, just to reiterate, please message me throughout during the chat box if anything springs to mind, and we'll address it towards the end of the session. Other than that, let me pass on to Susie, please.
Hello, good morning everybody. Thank you for taking your time out of actually quite a sunny day for once to come and listen to our IHT webinar. IHT, as I'm sure you're all aware, is a really large topic. So some of what we're going to be touching on today is really just that. We'll be covering some topics, but quite briefly. If there is anything, obviously, that you wish to ask more about, or anything that raises further questions for you, then please don't hesitate to get in contact, because I'm speaking for myself and Georgina here, and that we'll always be happy to have a chat with people separately, on the phone, privately, however they wish to do it. Because obviously there is some of these areas we could go on for hours about, but we won't be today, because we obviously appreciate you've all got other things to be doing. So in general terms, IHT, as I say, inheritance tax, broad topic. For a lot of people, their first concern is, well, will it affect me? Generally speaking now, due to the reliefs that are available on death, most people where their estates, if you've got a married couple, for instance, have generally got up to about £1 million before they worry about needing to pay the inheritance tax on death. So that's broadly speaking, or at least that will be the case by 2021. I'm not going to go into too much detail in terms of the allowances that make up that magic million, but broadly speaking, anything above that is likely to be taxed unless you own any investments which come with a particular privileged status for inheritance tax points of view. So one of the questions, obviously, that we opened up to anyone with in terms of this webinar was, people obviously often say they've saved all their lives, they're in retirement. How do they know what they can actually afford to give away? How can they plan for inheritance tax when they don't know what they may need throughout the remainder of their life? Now that is obviously a really challenging question, because none of us, despite all of the advances in modern medicine and technology, know the date at which we're no longer going to be here. From a planning point of view, it makes everyone's lives a lot easier, although I appreciate it's quite a morbid thing to have to think about. So what we look to do with clients is put a plan together broadly. and everyone's retirement, everyone's needs is different. That's the first thing I'll say. There's no one size fits all, as with all areas of financial planning. So putting a plan together can be as simple as looking at what we would call cash flow analysis. And cash flow analysis aims to give clients an idea of where they are today and what their factors in their expenditure, factors in their assets, growth, likely charges that would come out of their portfolio, and other events that may happen along the way, potential inheritances, even factoring in things like care costs further down the line. That then can help give clients some reassurance about the money that's effectively surplus within their estate. Now, obviously, it's not an exact science, so there's always areas that need to be addressed throughout the journey, and that's the one thing I'll say to people, is it's very important, obviously, to keep reassessing the plan regularly. So don't just set out a plan at age 65 and think that nothing's going to change between now and the day that you leave this lovely planet. You do have to address it along the way, and that's any good financial planner, any good solicitor will obviously assist you in doing that along the way. So that's the first thing I would suggest, is putting together a cash flow plan to indicate what might be effectively surplus. Then you can say, well, okay, what do I do? I know I've got an inheritance tax problem. I know my total assets are greater than £1 million. I know that potentially £500,000 of my assets I'm not going to need throughout my life, because the cash flow plan has indicated that. What do I do now? Well, the first thing I always say to people is small changes can have a big impact over the longer term. So look to make sure you're utilising your regular exemptions. Really simple things. Everybody has a £3,000 annual gift allowance that they can make. Make sure you're using it. Gift money to family regularly. You can also gift out of regular expenditure, and this is something I always suggest to people they consider, because it's something that's often overlooked. If at the end of each year, when you sit down and you look at your accounts, you realise actually you've saved money over that year, all you're doing there, although it's a good practice to have, is effectively adding potentially to that IHT problem. So one thing that can be done, if when you look at your total income versus your expenditure, you do have a surplus in terms of income, that can actually be gifted away. And provided that gifting is regular and habitual, and it doesn't mean that has to be weekly, it doesn't even mean it has to be annual, it could be once every couple of years you make a gift, as long as it's habitual and it's documented and it comes out of that surplus income, not capital, again, that gift is IHT exempt. So one strategy we sometimes look at for clients is actually increasing their income, even though they don't need it in retirement, just so they can gift it away, rather than that income accumulating in their investment plans and causing them a further IHT problem down the line. So even some small changes like that can have a big impact. The other thing, obviously, then people can look to do is larger gifts. Obviously, they have to be aware of the potential tax considerations that come with those. And also gifts into trust. And that's something I'm going to come on to now in terms of, again, this is a really brief overview, so I appreciate that some of you may have much more specific questions regarding trusts. But one of the questions we get asked a lot is, well, surely I can just put my house into trust for my children. That will work. Well, actually, no, it won't. Unless you're then willing to pay market rent to your children throughout the whole of your retirement. It's classed as a gift with reservation of benefit. And it's effectively they're null and void from an inheritance tax point of view. So anyone who ever tells you just to gift your property into trust and that it's fine, that doesn't work. Funnily enough, the taxman's thought of that one and made sure that that loophole is closed. So that doesn't work. However, you can put other things, other properties into trust potentially. There are again issues with doing so. Any gift of an asset is a disposal for capital gains tax purposes. So if you had a rental property that you were looking to place into trust, which is I think one of the questions that we've actually had sent in today, that would be doing so would be a disposal for capital gains tax purposes. However, the trust and beneficiaries could claim a relief called holdover relief, so they didn't have to pay any capital gains tax at the point the gift went into the trust. However, if that property was providing you with vital income throughout retirement, you have now lost access to that income. That income is now part of the trust, and as a settler, as the donor, the person who's made the gift into the trust, you cannot again receive that income unless it then effectively null and voids the trust for inheritance tax purposes, because again it's classed with the gift with reservation of benefit. So that's the one of the big downsides with trusts, putting property particularly into trusts, is the main one is the lack of access. So any money you put into a trust, you are effectively giving up the right to that money. It's no longer yours, although you have control over who receives it ultimately and how they receive it. You no longer have the option to just take it back. It's gone. It's out of your estate. It normally takes 7 years for the gift to be completely outside of your estate. And again, that's something that people need to be aware of as part of their wider planning. The other thing, obviously, to consider is that the rates of tax that the trust pays internally sometimes mean that putting assets such as a property or even an investment portfolio, depending on the wrapper that the investment portfolio is in, is actually not a great idea from a day-to-day tax planning point of view. Trusts have smaller capital gains tax allowances and income tax allowances and pay income tax at a higher rate than we all do as individuals. So again, they're not always suitable for all types of planning. It's not to say that they're not a good thing to consider, and appreciate obviously that people often use trusts. As I say, it does provide an element of control. It means that rather than gifting money to grandchildren outright and then they then go on a nice round trip around the world and don't have anything left at the end of it, you can dictate how and when that money is used, at what point they get access to those funds. So trusts, as I say, can be a very useful tool in the right way, and there's something that people do consider as part of wider inheritance tax planning. So that is broadly on those two areas. I know Georgina's obviously got some answers for you as well on some of the legal aspects of inheritance tax and planning a will. At the end of this, as Melissa said, there will be the opportunity as well for specific further questions to be addressed. So please feel free to pop anything in the chat box that you wish to be addressed. Over to you, Georgina.
Thank you, Susie. Thank you very much to Susie for that. My name is Georgina Layton. I work within the private client team here at Goody, Burrett. And I think this is the first event of this nature that we've been involved in. And there are so many areas that we could have addressed for you, really. So I've gone with the 3 most common questions that we get here within the private client team. And the first is, why should I be making a will in the first place? And I think really it ties perfectly into what Susie was saying, in that it really is the most effective and the most efficient way that you can estate plan for after your death. And it is the wrapper really that kind of finishes off all of that work that professionals and advisors such as myself and Susie have done to assist you in maximising the wealth that you can pass on to your potential beneficiaries. But it's only by reviewing the finances within your estate, and I think knowing what the allowances are, the reliefs that you can have, so that you're aware of what your tax status is potentially, to know whether there is any mitigation that can be done to, I guess, plan for the financial independence of your loved ones, so that they are able to maintain the lifestyle and the financial security that you had whilst you were alive. I think, touching on the intestacy rules, if you're engaging in estate planning and you don't finish it off with a will, intestacy rules are effectively government legislation that dictates exactly how and to whom your estate is divided, and it can lead to some really unexpected consequences. And I think, when you are estate planning, there are no stupid questions, and I'm sure that Susie would agree with this. Actually, if you're not sure on a point, please make sure that you do ask your advisors. I think one of the most common misconceptions that we encounter is that just because you are a married couple, everything is going to pass automatically to the surviving spouse on your death whether or not there's a will in place. And actually, this isn't the case at all. You know, there are many different things that have to be taken into consideration, particularly if there are children involved. So, you know, if anything, do make sure that you know how the law is going to be applied on your estate, so that you are aware of where everything is going to go. I think the more complicated your family circumstances, the more beneficiaries you have to worry about, the more important it is that your will is clear and precise. And actually, really, your will will always be tailored to your individual circumstances, and it's within this that we can go through with you what you need to be thinking about. You know, are there minors to consider? You know, is guardianship an issue? Do you need to appoint guardians for your children? Do you need to consider, you know, potential trusts for minors or disabled beneficiaries? Are there any foreign assets that you need to think about? You know, even things, really basic things sometimes, such as, you know, your funeral wishes, you know, arrangements for beloved family pets. You know, the list is absolutely endless, but it is only kind of capturing it within the terms of your will that you can be clear what you want to be happening, really. And I think with regard to wills, finally, I say to all of my clients, like, transparency is absolutely key. I think, you know, whether kind of you are sitting here and your will is done and dusted and, you know, secured safely, or whether you need to enter into your will, you know, make sure that your executors are aware that you've appointed them as executors. Make sure you've taken them through what you are intending to happen by the terms of your will. Make sure you've spoken to your beneficiaries, actually, about what's going to happen after your death. And I think, you know, the clearer you can be, the better, really. And the only person that truly has the answers as to why your will has been drafted the way it is you. As much as solicitors' telephone notes and file notes and attendance notes can sometimes be used to assist families in trying to understand why a will was drafted the way that it was, you're the only person that can give them those answers. So do make sure that you are being as clear as possible, and that there are no surprises, really. Leading to the second point, it's kind of the more complicated scenario that we come across a lot now, with relation to, you know, blended families and second marriages. And we come across an awful lot of couples who come into us and say, do you know, we would have come a lot earlier, but we felt that our circumstances were too complicated. And can I successfully provide, you know, the financial security that I'd like my spouse to have, as well as providing for children from my first marriage, you know, whether it be both first marriages or just one. And I guess the answer is, firstly, that because there are more people to worry about, always make sure that you're taking advice, the more complicated something is. But yeah, absolutely, these are the things that can be really squared off quite nicely within the terms of your will. Very often, touching on what Susie said, it can be another mechanism that trust arrangements are used for. So you can absolutely make sure within the terms of that trust that for the lifetime of the spouse, they are financially secure and they have the funds required to maintain their lifestyle, whilst making sure that children are ultimately going to inherit with the way that you want them to. And I think the other thing as well, sort of just going back to, you know, arguments that can arise within the terms of wills, talking to colleagues kind of in doing some research on the run up to this webinar, interestingly, the biggest source of argument over the last few years is within second marriages, and it's actually funeral arrangements. You know, the arguments that we see between the surviving spouse and children from the first marriage about how their loved one would have liked their funeral to be held, and in particular the ongoing arguments that we see over the ashes at the end of the funeral. you know, be as clear as you possibly can, because these things do crop up. And I think thirdly, the other thing that we always touch on with people that comes up is, you know, people say to us, right, okay, I've addressed my will. Is there anything else that I can be doing? Firstly, I think powers of attorney don't get the airtime that they deserve in terms of how they can assist somebody. So, you know, considering a situation where you might not be able to manage your own affairs as well as you would like in the future, you've got financial property powers of attorney where you can authorise your chosen loved ones to manage your finances on your behalf. But you've also got health and welfare powers of attorney. That's a very topical subject currently, understandably, you know, authorising your loved ones to make decisions about your health and about your welfare. Should you not have the capacity to do so, you know, should there be a catastrophic event, should you end up in a coma or, you know, end up on a ventilator, anything like that. And importantly, I think within those health and welfare powers of attorney, you can authorise your loved ones to make end-of-life decisions for you. So you can authorise them to refuse or to accept life-sustaining treatment that might be suggested to you by doctors in that scenario. And I think business powers of attorney as well. You know, if you are a high-level decision maker within a business, you know, looking around your boardroom, who would you want to be making those decisions if you weren't able to make them in the future? And actually, it's a good conversation to have, because very often the people that we would want to make decisions about our kind of personal finances and health and welfare matters are very different. It's a very different skill set that's required to the people that you would trust to make your business decisions. And I think one of the final points to make is that we would always say, you know, coming right back to the beginning of this presentation with Susie, you know, make sure you are keeping your finances under regular review. And I think probably from both of our perspectives, having kind of the legal base and the financial base will best place you for all of those financial decisions that you have to make, because lifetime planning is just as important. You know, maximising your wealth for during your lifetime, using the allowances that are available to you, you know, using the exemptions and the reliefs, putting yourself into the best financial position that you possibly can during your lifetime will mean that actually things are so much easier when you get to the point of your death as well, whichever it may be. So I hope that's touched upon some of the issues that some of you may have had coming to this webinar today. Thank you for your time. I think we're going to head back to Melissa now, who's going to go through some of the queries that have come.
While you have been talking, I have actually, I've got another one come in. There was a question about estate planning, which I think is, I think it's probably Jornita, but I'll just pitch it out to you. Well, I don't know who this is. Presumably, the earlier to start estate planning or reducing the estate size, the better. If one can afford it, should we be making the maximum available gift to children next of kin from as young as possible?
I think we would probably both say absolutely to that. Yeah, make sure you get yourself into, Susie, review your finances. The earlier you start, the better, because it might be that even if you can't do anything at this point in time, you can have the correct advice as to what you could be planning for in the future as your finances kind of improve.
Susie, yeah?
No, absolutely. Yeah. I completely agree, and that's again where we would link back to the cash flow planning, because then it's not really a guess. You know, yes, obviously circumstances will change, and that's why the cash flow plan needs to be visited regularly. But based on, you know, what you're drawing, what your income needs are, what your expenses are, scenarios and things that could crop up in the future, it will help to give you an idea of what is truly surplus and what you really can afford to potentially look to give away. And then it is not just a guess. It is worth saying as well that there are some types of trust planning that can be done whereby you don't lose access to all of the money that's gifted. Potentially there's some where just the growth sits outside of your estate on the trust investments, but the capital that's used to start the trust off, you can still dip into and access. So again, if it was to be needed later in life for other needs, you can, but it helps to cap effectively the value of your estate. And there's also other types of trust whereby you can take a regular income for up to, say, 20 years. Again, it's a discretionary gift trust. And that can also help provide some certainty over that you're not going to lose entire access to the money that's given away. One other thing I just want to say as well, which really links back to what Georgina was saying, and that it's really important that people do have powers of attorney. We often, similar with the will scenario really, where people think that because they're married, that means that each other has the ability to give instructions or directions on each other's finances. That's unfortunately not the case. And if you have a pension that sits in your own name, the provider will insist on there being a power. If something happens to you, power of attorney would need to be in place for your spouse to give instructions to the insurance company over what was to happen to the pension, withdrawals, a lot of things that would be needed. Or if there's not a power of attorney in place, then you would have to go to the court of protection, unfortunately, which is a very lengthy and expensive process. So it is really, really important that those I's are dotted and those T's are crossed when it comes to personal finance. And powers of attorney are not just for the elderly. I know people tend to think it's only if they get dementia, but there's 1,001 things that can happen to each of us every day that would mean you're no longer able to manage your own affairs. I won't obviously go into a real list of all the horrible things that can happen to us, but unfortunately there are quite a few.
Actually, on that subject, I'm not going to let you go, Susie, because I think this second question that's popped up just now is for you as well. Have the financial institutions got better at accepting formal copies of power of attorney as the sole legal document needed to take action, instead of going through the whole process themselves as well?
That is a good question, and one I'm not entirely sure really. Georgina, do you say they have, or?
Yeah, I think they have. It used to be a few years ago, the position was that unfortunately, kind of on high street level, the bank managers and so on weren't overly clear on what they were able to do if an attorney presented them with a power of attorney. And I think one of the things we say to all of our clients is, you just make sure you're dealing at a higher level than that, because generally, actually, the asset companies and the banks are a lot clearer now. You just have to make sure you're dealing with the kind of the department of the bank that deals with it. So much like, these days, high street banks are not very good always at the probate side of things, because the banks have now got their own bereavement centres. For deputyship issues and power of attorney issues, most banks have got their own kind of departments to deal with those. So if you can try and deal with those specifically, you'll have a lot smoother ride. And I think it should be much easier with, I guess, people like you guys, because you're obviously clear on what you can and can't be doing with them. So if you've got an advisor involved as well, things will be so much easier for you, I think.
Thank you, Georgina. I've got some email questions as well from the other day, but before, I've just had another chat question come in. I think this one is for Susie. Is there any benefit to having an NRB trust in your will anymore because of the transfer of allowances?
Probably one for Georgina, but
I don't know.
Sorry, Bliss.
I don't know. But...
Yeah, I think we probably give the same answer. I think if it's a straightforward circumstance where there's only one kind of nil rate band to capture, then absolutely, you can have a straightforward will set up and you will get the tax allowance from the nil rate band. But I think perhaps the more complicated your circumstances, say for example, if you're a widow or you're a widower and you've got the potential for maybe 2 nil rate bands, that's when you do need to be making sure that you're seeking our advice, so that we can do all we can to capture any additional nil rate band that you may have kind of lurking in the background that would make potentially quite a big difference to your tax situation at your death.
Thank you. So we sent an email out the other day asking if any of you had any particular specific questions you wanted to send through in advance, and I did get a couple. So I'm just going to read those out now, and I imagine they're quite complex, so I imagine they'll be answered by both of you. So I'll just start with the first one, which is, what are the advantages and pitfalls of buying a property to retire to retire either with or separately purchase nearby agricultural land or woodland in order to reduce tax liability? Are there specific land classification or other criteria which need to be met? And if agricultural land, does it have to be worked, or would rewilding not prejudice the status for IHT purposes?
So there's actually about 8 questions there. So I thought you were going to one at a time, Melissa. But anyway, yes, basically.
Yeah, no, there is a second one, but that's, yeah, the first.
That's fine. You're fine. I'm only teasing. So yes, basically, agricultural land and woodland does have its own special privileged status. So it doesn't mean that you can just, you know, pop out the door and buy some woods and it's fine, and that's automatically exempt from your estate. There have to be certain criteria that had to be met in order for the woodland to either qualify for agricultural relief, business property relief, or there's another type of relief called woodlands relief. Broadly speaking, though, you want it to qualify for one of the first two, which is either agricultural relief or a business relief, because if it's the woodlands relief, you only effectively, the IHT exempt bit is only actually the value of the wood, so it's not the land, and that obviously is less beneficial than having the entire land value exempt from your estate. So under agricultural relief, normally that applies where you've got some farmland and some land that is being farmed, and there's an adjacent piece of woodland that falls in part of the farmland. If it's rented out, so i.e. you're not the farmer, then that can potentially cause some issues further down the line, so that's something to be aware of. If it's rented, it's there as a business, so you buy some woods, you then decide you're going to work those woods in terms of, you know, for the timber, you use it as a functional business, then potentially that can also qualify for business relief. So there's different reliefs that can apply. It really would depend on the individual circumstances and the scenario in which you look to hold that land, which is why we'd always recommend not just, you know, popping out the back of your door and finding some woods down the road. It has to be some planning around the type of woods that you're looking to achieve, and also what the ultimate purpose is going to be. Likewise with farmland, really. One of the issues we work with farmers a fair bit, and one of the issues that you have is where as the farmers get older, they decide they no longer wish to work the land themselves, and they'll rent out that land obviously to be farmed, which in a lot of cases can still qualify for agricultural relief. But you do have to be a bit careful, particularly around the farmhouse building itself, and whether or not the operations of the farm are still being conducted from the farmhouse. Because if they're not, then sometimes the farmhouse itself, which is often the most valuable element of the farm land, depends how big the farm is, may not qualify. And equally, outbuildings, again, they have to be being used, they're derelict, and they may not qualify under agricultural relief. So there's various things and pitfalls to be aware of. It can be quite complicated, but it is an area of diversification that some people use. Obviously the reliefs are there to help stop farmers having their land, having to sell their land on death to pay any taxes that would otherwise be due for inheritance tax. So it's there to help the farming community, really.
Yeah.
So that's the first part. What was the question?
I was actually, with the second one, it's equally complex. So I'm actually going to paste it into the chat so that you can come back. Do you want to add anything to the last one, Regina?
Sorry, no, I was just, everything that Susie said is spot on, really. I think probably just to reiterate what she said at the end, I think the revenue and the legislation writing over the last few years has meant that their definition, particularly in relation to agricultural law, the definitions that they work with to ensure that you get the reliefs have just narrowed and narrowed and narrowed. And now it's very much the case that, you know, it's very much that, sorry to repeat myself, that if you are in a farming family and you have the land, you have the woodland, then yeah, absolutely, make sure that all of these reliefs and exemptions are being used in the way that you can. And, you know, by all means, tweak what you're doing kind of as farmers or a farming family to make sure that you get those reliefs. But it's becoming harder and harder, I think, from people outside of the farming community to decide now that they would like to make use of these reliefs. So they're going to buy X, Y, and Z to help with their tax allowance. So you do have to be very careful and make sure you take the right advice, because otherwise you might effectively end up spending an awful lot of money and not mitigating your tax bill in the way that you thought perhaps you were.
Okay, similar kind of area. I'm just going to paste it in the chat, which I think I've just done, but I will read it out as well. What are the advantages and disadvantages of transferring ownership of our buy-to-let property to a trust benefiting our children, but written to allow us to benefit from the rental income? In the event that it became too much of a maintenance burden on us, what would be the implications upon the trust of selling the property and investing the proceeds, again with us enjoying the benefit of the income? Alternatively, is there any tax efficient mechanism to gradually gift ownership direct over a number of years?
I'll also, before I launch into that one, Melissa, I will just comment, Simon's just posted in the chat as well about rewilding and prejudicing the reliefs. Broadly speaking, it comes back to the point about if you have a woodland, it would need to be worked. So you couldn't, for instance, just have normally the land as grazing for horses or recreation. That wouldn't normally then class as qualifying for agricultural relief or business relief. If the land was just going to be literally left to go wild and you weren't going to look to do anything with it in terms of either farming or the having any kind of business around the woodlands, then generally speaking it wouldn't qualify normally for any of the relief. So there has to be you know, there has to be a purpose behind it. It's possible that the woodland relief could apply if it's, again, that's normally for, you know, areas of outstanding natural beauty and things like that, where there are some various reliefs there. But again, as I said earlier on, that's really just for the value of the timber, not for the value of the land itself. So generally speaking, in all these cases, to qualify for these reliefs, the land would need to be worked in some form, have a business or an agricultural purpose. On the property question, again, it links back to the sort of first part of what I talked about with the questions. Putting a buy-to-let property in trust is possible, but it would be a disposal for capital gains tax. So the trust would normally then look to claim holdover relief, so that there's no capital gains paid, capital gains tax paid at the point it went into the trust, and effectively the beneficiaries would get the original acquisition price of the property as their acquisition price, and then there would be tax to pay if they ever then, or the trust ever then, disposed of it. The issue though is that, as I said, it would be if the income was going into the trust and then the donor, the person who'd gifted the property into trust, was keeping that income to meet their standard of living in retirement, that would be null and void for IHT purposes, because it's classed with the gift of reservation of benefit. So it wouldn't be something that we'd ever recommend somebody look to do. Obviously they could give up the rental income, and that would then go to the beneficiaries. That scenario would obviously work for IHT, because the donor is not keeping any benefit of the original gift. Equally, that the property could be sold and then the money used to form a trust. Under the type of trust that you'd need to have in order to regain or keep an income from it, it would need to be quite specific. So it couldn't just use a normal discretionary trust. There would have to be a discounted gift trust or a gift and loan trust to allow the donor to keep receiving an income stream from the portfolio. Again, otherwise it would null and void from an IHT perspective. So there is planning that can be done there. generally speaking, it's easier to form a trust using cash than it is using property because of those sort of issues. It's not to say it can't be done, it can, you just have to be aware that you then have to give up the right to income and other things. There's also potential entry charges with any trust. It really depends on the value of the asset that's being put into trust. So if the value of the buy-to-let property was above £325,000, for instance, then that could cause an immediate tax charge for IHT as well on that gift into trust. So that's, again, just something to be aware of when people are looking at the planning. Going on to the sort of, I think it was the next part of the question, it is possible.
You want me to read it out again? Or?
No, it's fine. Well, if there's any bits I've missed, I'm sure people will let me know. But it is possible to obviously gift part of a property or do gifts over many years to a beneficiary. They have to just be aware again, though, that they can't obviously retain the rental income on that. That element of the rental income would then go to the person it's been gifted to. And also you'd have to bear in mind that each time you make a gift, the 7-year clock starts ticking. So if you were to make, give away a quarter of the property over 4 years, the 7-year clock on that last gift obviously is only starting in 4 years' time. It's not starting today. So it just means that you've obviously got to have the life expectancy there to outlive the gifts.
Okay, cool. Georgine, did you want to add anything to that, or I think that's
pretty much, yeah, that's pretty much bang on, really.
Sorry, I talked a lot then.
Pretty comprehensive. So yeah, a big question. I've got another question popped up from Matt. What's the legal implication of somebody dying without a will, but they promised a possession to someone?
Technically, it relies on the goodwill of the people that are involved, i.e. the people that are due to benefit under the intestacy rules. So if you die without a will and various promises have been made, it would be up to the administrators of the estate basically to assess these promises on a case-by-case basis to see actually if they are possible, if it can be that they can be followed through in some way, depending on the circumstances, whether they're willing to, whether the beneficiaries are willing to give up the possessions that they kind of now have a right to under the intestacy rules. So yeah, negotiation could be done and arrangements can be made. But I guess going back to what we were saying earlier, to avoid all of that, if there are any specific possessions that you do want to give away, it needs to be within the terms of a properly drafted will to avoid all of that discussion. Because ultimately, if the beneficiaries say no, they're not willing to amend the intestacy rules, then yeah, there isn't going to be much you can do about it.
Okay. Has anyone else got any more questions they wanted to post in? No, I do have a couple of others that we had come in the other day for, yeah, well, for both of you really. One of them was, who should I appoint as executors and when should I consider appointing professional executors?
I think the executor very much depends on your own individual circumstances. So sometimes there will be an obvious answer, if there is a surviving spouse and they are happy kind of with the work involved as being a executor, then it makes perfect sense for them to be named as maybe one or more executors, because it's their financial independence that you're trying to determine under the terms of the will. If your circumstances are more complicated or there's no obvious person that you would trust to be executor, then you can look at appointing professionals. So if you perceive arguments between beneficiaries potentially, then yeah, you can certainly look to solicitors or advisors. I don't know if you come across that much, Susie, in honesty, but yeah.
We have done historically. Generally speaking, it's something that we tend to suggest we don't do, just because of any potential conflicts of interest with us looking after investment portfolios and being executors. Yeah. We have certainly done that in the past, and obviously if there was a situation where a client literally had nobody else that they felt they could trust, then obviously we could potentially look to do that for them. But generally speaking, we suggest that they try and find family if there is somebody there to do that for them.
And I think the other important point to make as well is that you don't need to feel that there is a certain skill set that's necessary to be an executor, because of course the likes of Susie and myself are available if you feel you're going to need financial advice or legal advice in carrying out the terms of the will. So ultimately, if simply you just want to give your signature to the probate process as you're going through, then yeah, we can take you through it. The likes of Susie's available to provide financial advice, so you do have lots of different options.
That's actually really interesting, because it kind of leads into another question that I had emailed through. How involved is the power of attorney process, and do I have to give up complete control of my finances, as that is something that would worry me?
Yeah, we hear this a lot from clients actually, and I think their biggest worry is that they put their signature on the financial power of attorney and kind of that's it. And I guess I would always say that with your financial power of attorney, in truth, it's more of until the point that you lose capacity, it's more of a kind of master servant kind of relationship, in that you can have your attorneys be as involved as you want them to be. So if it is the case that you are becoming more housebound perhaps, and you're not making the trips to the post office that you used to, setting up direct debits, things like that, but you still want to be in control of the bigger decisions that you make in relation to your finances, then yeah, absolutely, you just have your attorneys do the bits that you want them to do to assist you to make managing your finances easier. And that works very well for the majority of our clients. I think particularly going back to kind of the elderly client base that we have that draws up powers of attorney, they very much do it in that way. They do it so that they know they've got peace of mind if they require assistance for any reason, but that actually they are the ones that are still in control until the point that they lose capacity. So I guess the answer really is that you give up as much or as little control as you want to until the point that you've lost capacity.
And just one other short email that I had in, you've answered it partially there. Can my attorneys seek professional financial advice when they're acting for me? Yeah,
absolutely. And I think, in executing their duties as a professional attorney, kind of once they've signed up to assist you, really they would be acting in your best interests by making sure that they're taking the advice that they need, and especially having financial advisors involved. If the finances are of such that they always used to be, you always used to have the assistance of an accountant or a financial advisor, then yes, absolutely, you can carry on doing that as attorney.
Okay, thank you, Georgina. I don't know who will answer this one. One that's just come in from Jenny. I have a 96-year-old father owning his house. Is there anything we could suggest to him to mitigate IHT for myself and 2 siblings?
So this is a tricky one, Jenny, just because of the age of your dad. And obviously normal gifts would take 7 years to leave the estate. So it's likely, I don't know his health or anything else, but it's likely just through age that he may not unfortunately have the 7 years available there to that gift to fully leave his estate. So in terms of other options, one thing that could potentially be looked at, and again this is just off the top of my head, so to have to seek advice from other professionals on this, but whether or not he could get any form of equity release to release some of the value that's linked up in that property, whether he could do so. If he then could, it could be possible for the cash that's released from the property via the equity release to then be reinvested into a form of investment that qualifies for business relief. And there are different types of investments that do qualify for that relief. out there. There's plans where you can go as risky as you like. So there's things at the risky end of the spectrum, like AIM shares, for instance, qualify for business relief and are normally exempt for IHT once somebody's held them for 2 years. But appreciate, obviously, at 96, you probably aren't too concerned about large returns. It's more about preserving the value of his estate. So there are much lower risk options available out there which do look to target just preservation of capital. So they provide a low 2 or 3% return each year, with the intention really of the person who's made those investments survives for 2 years, and therefore the value of those falls outside their estate for inheritance tax. Equity release is always a difficult one though, because I appreciate that people don't often like the idea of it, the idea of sort of losing. They've worked very hard all their life to have no mortgage, so the idea then that they have that debt on the property can put a lot of people off. Again, the thought of the fees increasing up in the mortgage again can put people off. So I always say seek advice. There are other options out there where the interest, I believe, is serviced on a monthly basis to stop the value of the property being eroded by the debt building up over years. So there are potentially things that can be done, but I would also suggest, obviously, without knowing the makeup of his estate, you would want to look at, well, what element is made up of property. Does he have any more liquid assets in terms of savings or other things that, again, you could do planning around without having to touch the value of the property, and looking back as well as to whether he qualifies, whether it's just his nil rate band and allowance that he has, or whether he has potentially that of a spouse, former loved one, that you could also offset against the total value of his estate. So you need to ultimately look at the real bigger picture in terms of all his assets.
Okay, right. We haven't got any more questions. Just wanted to add that I think Georgina has put her, I don't know if you've done it yet, Susie. Have you put your contact details in?
Oh, no, I haven't. Let me do that. We need to make, Georgina, I think yours are just to the panelists though, so I don't know whether everyone else will be able to see those.
Yeah, no, they are. I can do it now if you like. I can just paste it.
I do all panelists. I know Lisa will be also sending out, obviously, the webinar for everybody afterwards.
Yeah.
Have you pasted it? Your details.
I have now. Yeah.
Yeah.
Okay. So you've both done that. So really, I've just checked the chat box again. I don't think anyone's got any further questions. I hope you found it all really useful, and if you have any further questions, then please do just email either Georgina, Susie, or myself. As I mentioned at the beginning, I will be editing the recording and sending it through to you. I've got all your email addresses from when you registered, so that will, if you want to go over anything that way or share it with anyone else who might be helpful for, then you can do that. And I just want to, well, we all want to thank you for